seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand that there's a recusal application today. But given the fact, my Lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my Lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my Lord, the orders in question were issued by one judge. The matter has now been referred to a 3-judge bench. And their nature is problematic, as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be heard in cohort 2, that if possible, my lords, we do not want to do anything outside the law. We would request, my Lord, that we be heard today, if it's possible, because the orders expire today. I think Malaya Frederick Gumbo would just want to add something on that.
My Lord, very briefly, I only want to repeat what my Lord, I just wanted to indicate that I would not want to repeat what Senior Counsel Professor Tom has indicated, but just for completeness of record, there are 2 applications. There's one by the Honorable Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready to go there for them as soon as direct.
My Lord, with your kind permission, Daniel Manson, appearing for the Law Society of Kenya and also for White Party Democratic Party or interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest, after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
My Lord, Kibe Mungai, on behalf of the petitioners, there are 2 issues. You can see the senior, the team leader of Muite is not with us in the council. That is the first thing that we deal with it in the afternoon. And as far as we are concerned, the matter is premature at the hearing and determination of that applications for the simple reason that the issue and an order had already been made that will be first dealt with by the court after its ruling of yesterday. Was the application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my Lord, of a back and forth on what is to be heard first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Muite is in the afternoon, it will be not in the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are 3 things actually that we would like our reactions on behalf of the petitioners. Number 1, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutunga rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions, if either or, from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. Now, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last position, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we had requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses. Because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because as you have said, these are interim directions. And number 3, in order to be able to determine issues for determination, and these are the issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require clause of pleadings. And the clause of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
I think because I've wanted to say perhaps so you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kilgore, Your Lordship, was categorical that he granted prayer number C, even as we await Senior Counsel Paul Muite to come in the afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner, that pending the hearing and determination, of this application inter partes, this honorable court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that Senior Counsel was raising has no sitting in the pleadings before you. Number 2, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I've had the advocate for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following. He doesn't seem to be following. Why do you say that? But why do you say that? But let me leave it at that.
Thank you. I think that is, sorry, gentlemen, you cannot talk forever.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for filing of responses, because as we speak now, we have not received those responses from the respondents. Then number two, my colleague Senior Kibe had raised issues on filing of responses, so that in 522 we had given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1. Finally, my Lord, this proceeding, because of the nature, the way they are proceeding, would request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding again at any time, those can be availed for purposes of good order. That is all.
May I say something?
With due respect to Counsel, we did not intend to make today this hearing a long hearing. We have been courteous enough, we have read our directions, and I think you should let us wait for proceedings in the afternoon.
I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to, when actually it should be the amendments that should come first and then responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kiroya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that urgency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
I apologize. We are raising too many issues. I do apologize. And we thank you for your question. When I made an application for Petitioner to be joined, my Lord Justice Okola, you were very kind enough to promptly allow my application. Petitioner was to be joined, and also I was to be joined by my name. You have not mentioned it. If you would be kind enough to
In which petition?
Yeah.
In which one?
Which
cohort?
This, I'm sorry, I don't have papers, but this one for
in your own name?
Yes, in my own name. John M. Hamilton. And of course, it was in
So you are petitioner number 8?
No.
Interested party number 8?
That's all. Thank you very much.
Thank you, my Lord. We just want to restate the position that the urgency in this matter cannot be gainsaid or cannot be lost, my Lord. Under the contention that the replies have not been met, that we have not met replies, is not correct, because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empanelment of these judges will actually be lost, because then we will be going back and forth, and at the end of the day, my Lord, we will not have served the public the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings. But one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether a petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We look at two parts.